Joe Infranco, Senior Counsel, Alliance Defending Freedom, is with us. And Joe, really, thank you so much. I know it's been a crazy, hectic day, and I know you're doing a lot, and we appreciate your time, sir.
Hi, Steve. Pleasure to be with you.
Well, thank you. Okay, now when I heard another member of your team on CNN, I immediately said to my producer, "We got to get somebody from this organization, because this is and Wolf Blitzer almost like fainted because this was the first time we had heard this analysis. Am I correct? And I'm not a lawyer, so bear with me. Am I correct that what you guys are saying is that this Prop 8 has not been overturned, it cannot be overturned, because the only court ruling that stands now, according to the Supreme Court action, they vacated the appellate court decision, and it's just a single judge. And the California state constitution demands that for this, for Prop 8 to be ruled unconstitutional, notwithstanding the finding of the lower court judge, an appellate court has to decide on it, and now that's been vacated. Am I reading this correctly?
That's essentially correct. California law says that a proposition, a voter-passed initiative, cannot be voided by a trial-level judge. It has to be an appellate court or higher. And, of course, the Supreme Court did not rule on the merits of Proposition 8. There was no knockout punch. There was no finding there's a right to so-called same-sex marriage. There was simply a finding that there was no standing. But when they when they vacated the Ninth Circuit's decision, that leaves Proposition 8 technically with no federal appellate court decision on record. And now, what happens to the trial court decision is it does potentially apply to the parties to the litigation. But, the sort of rush to judgment now, and, Governor Brown announcing he's going to start ordering clerks to issue licenses within 30 days is way premature. There's a lot of lawyering left in this case.
Okay, so I'm glad you said it was premature, and that's what he has said, and that's what his Attorney General has said. That's what every media news outlet is saying. So what do you plan to do to stop that? What did you say? There's a lot of lawyering left. I assume your organization plans on being a part of that, having just fought this in the courts. So what's next for you guys?
Well, that's correct. I'll just say that we're evaluating our options in litigation. I don't think we're ready to disclose a particular strategy yet. As you can imagine, there's a lot that goes into this. But I think one of the things we have to do immediately is just slow up the train. So the reason that they're pushing for the immediate release of information is the other side wants to foreclose the debate. This is, we don't want to discuss this any longer. And on our side, we're saying, look, there are some very important issues to discuss. The union of a husband and wife is a timeless, universal, unique matter. And, there's got to be some public discourse continuing on issues like, does every child need a mother and a father? Should the state be in the business of creating, by design, relationships that intentionally deprive a child of either a mother or a father? Now, those may be uncomfortable decisions, or rather discussions, but they're precisely the types of discussions that have to continue. So we're going to slow up the train, and yes, we will be back in court. The options will probably be in state court, but there is a number of people who will be affected by this, clerks perhaps who are ordered to issue the licenses and others. And they'll have a different type of harm, and therefore a basis for standing beyond what the proponents of the initiative had in federal court.
All right, just explain that last part to me a little bit. The clerks, how would the clerks explain to me? I understand there's more court procedures ahead. You're not going to lay out exactly what legal tact you're going to follow, but you're saying slow down the train. This isn't done yet. But now then explain the last part about how this might expand or increase the standing or improve the standing. That part I didn't understand.
Sure. And let me do this for the non-attorneys, because these are confusing terms, I know. Standing in the general sense means somebody has the legal right. They have a kind of harm. They've suffered a type of harm that's individual, that's particular, and the court says, okay, you've got the kind of harm that we're going to allow you to bring that case. So in saying that the proponents of Proposition 8, that's the group of people who put it on the ballot, who ran the campaign and all of that, in saying that they had no standing, 5 members of the court in a 5-4 decision were saying basically you don't have that much additional unique harm above the average voter. So think of standing in those terms. Well, now let's shift, and all of a sudden, here's a clerk in a county, and just one example among many, who gets an order from the governor, and the order says you must start immediately issuing licenses to same-sex couples. And that clerk, let's say, does not want to do that. That clerk says, well, wait a minute. Proposition 8 has not been invalidated by an appeals court. The clerk might also say, I have, personal or moral or religious bases against this, or there's a number of things that could come up. But now that clerk, by being forced to issue those licenses, now has an individual, an identifiable type of harm. So essentially anyone in the mechanics of state government, the mechanism, I should say, of state government who's going to be compelled to take part in this can now say, hold on, you're asking me now to do something which may be potentially illegal, and I need clarification on that point. So that's how it now creates an individual harm for the person in that position.
Okay, I think you explained it. Now let me ask you about standing. Do you believe that there was I don't want to say double standard, but an inconsistency in the ruling on DOMA and Prop 8? Because has not, and again, I could be wrong, has not the Supreme Court in the past, this court in fact, ruled that Congress does not have standing to bring a case or to represent a case, and I'm probably wording it awkwardly. And was it not Congress that was involved in representing one side in the DOMA case?
Yes, you're right. And there was an inconsistency. It was pointed out by Justice Alito in a very good dissent. How is it that there's no standing for these proponents, but we find standing here? Standing is this kind of elastic standard, and sometimes, it becomes a philosophically driven decision for the judges. If this is a case we want to hear, we'll find standing, and if it's not, we won't. But there positively was an inconsistency. I will say this: the Roberts Supreme Court generally looks to limit standing. Their overall philosophical inclination is they want to make it a little tougher to get into the federal court. So in that sense, it's somewhat consistent. But I think that there is clearly an inconsistency between the two decisions, as you point out.
Okay, well, I appreciate it. So you could tell the people here listening, because they're not hearing it anywhere else, in your opinion, will gay marriages resume anytime soon in California?
I would say it's clearly an open question. There was no knockout punch scored in the case, contrary to the sort of the buzz in the popular media. I'm doing enough interviews today, all of us are, that I think hopefully this is getting out. But again, it's not surprising, because I think the other side is looking to short-circuit the debate. Anything that they can do to push to a desired result and not engage the debate, is of course beneficial to their orthodoxy. So I'd say very much it's very clear in California law. You need that appellate level decision or better to invalidate a proposition. And I hope people keep pointing this out. Wolf Blitzer seemed a little surprised, as you pointed out, when he heard that. Well, there's a reason why experts, so-called, on the other side are not mentioning it, because they're philosophically driven to the conclusion that they desire. So, this is going forward. Look, marriage predates government. And it to me is a horrifying thought that a trend that's about 10 years old, it's 10 years since the highest court in Massachusetts, the Massachusetts Supreme Judicial Court, ordered same-sex marriage for the first time in the country. It's about 10 years. The justices noted in oral argument that it's newer than the Internet. And our point is, my goodness, you don't undertake such a fundamental societal change that can have so much impact without really being clear. What does the social science evidence say? We have to, look, there are ways that we can address people if we're concerned about issues like benefits. If we want to have a compassionate, reasoned debate, we can do that. We can address the dignity of individuals. But you don't have to rush to redefine the defining institution of Western civilization because it's suddenly, politically expedient to do so. Let's slow up this debate. Let it continue. Look at the social science evidence. We are not leaving this fight.
Okay. I really appreciate your time and your explanation, Joe. Thank you.
It was my pleasure, Steve.
Take care.